Hey guys, Dark Angel here. So, interestingly enough, when I went back to review the first video that I did, I forgot that my cooling fans were on under my laptop, and it gave a lot of significant uh, feedback, a lot of noise distortion. So the first video was a bust. Okay, so that kind of was disappointing because those fans actually run so quiet. However, they're to the point to where they actually affect the mics on the laptop. So you have to turn the fans off in order to make a clear recording as to whatever it is you're doing. So basically, okay, so I want to get right off into this because this video is going to be a little lengthy, but not that lengthy. Okay. So this, what I have up here on the screen that you guys can see here is right to travel by law. Now you don't have to include that because you just don't have to. But this is a notice of liability and an affidavit of truth and facts. Now, as you guys seen in my past videos, I have showed you a few variations of notice of liability that I have created, holder in due course letters, etc., that I have created, and actually got some very good feedback on those. So here's one that is in the drawing. I've been working on this for the past couple of weeks now, and it's pretty much in its final stages. The highlighted areas is the subject of interest, okay, is what I want to call it, the subject of interest, okay. So notice of liability, affidavit of truth and facts. I invoke all rights and surrender none. The following affidavit of truth and facts clearly establish that the right to travel in your automobile without a license or registration is validated through the presentment of the following state and federal statutes as well as definitions. Did you catch that? State and federal statutes as well as definitions. I'm not even going to get off into all the case law of the Supreme Courts that goes into the right to travel and all that, because why? I want to keep this simple and straight to the point, direct. Okay? So, with that being said, if you decide that you would like to use this document, okay, in my document I've included all of my state statutes that reference motor vehicle as well as the definition of motor vehicle. In your document, what you're going to do is exclude my state statutes and my state definition and put yours in, insert yours in, okay? And then the rest of it can stay the same. Now, when you get down here into the bottom, don't worry, I'm going to read the document to you. I'm just giving you a quick overview side of it all. When you get down into the personal argument, you can change that and fit it to your cause, okay? This actual argument that I use within this, it's actually pretty powerful. So let's go back and we're going to read it page by page so that everybody gets an opportunity to see what is actually said and how the law is actually applied. State statute RCW 4620.001 section 1. No person may drive a motor vehicle upon a highway in the state without first obtaining a valid driver's license issued to Washington residents under this chapter. The only exceptions to this requirement are those expressly allowed by RCW 4620.025 commercial driver's license. Basically what they've done with this statute is they broadened the term motor vehicle. They've taken and broadened the term to include everyone, okay? Anyone driving, operating a car. And we also know that driving, operating, all those terms are commercial terms. However, we didn't get off into all that aspect because you do not want for whoever's reading this document to get bored. You want them to be informed as well as alerted to their actions and the actions that they take against you, okay, come under fire. State Statute RCW 46.04.320 definition. Now this is my state's definition of what a motor vehicle is. Motor vehicle means a vehicle that is self-propelled, and every vehicle that is propelled by electric power. Okay, that's what they call a motor vehicle. So basically, it's not even their definition is not even signifying that includes every vehicle. Okay, other than electric ones, and those are far and few in between. They go anywhere between electric wheelchairs, golf carts, things of that magnitude. We ain't gonna get off into all that because it's irrelevant. So the definition, their definition doesn't actually broaden the term motor vehicle. It's the statute itself that broadened the term motor vehicle. Okay, so there's where your trouble begins, because here's the thing: the federal definition of a motor vehicle applies to all states, all 50 states. Federal definition motor vehicle pursuant to 18 U.S.C. Code 31 definitions, motor vehicle definition at 6. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in transportation of passengers and property or cargo. Did you hear the key word there? The key word in this whole case is, in this whole definition, is the word and. Why? Because and is not including commercial vehicles in the overall aspect of vehicles on the highway. It is describing to you what a motor vehicle is and what it is used for, conjoining two sentences, the term and. Okay? Conjoining two subjects of one subject matter. Okay? The term and defines and specifies specifically what a motor vehicle is, what it means. Okay? So, at 10, the term used for commercial purposes means the carriage of persons, property, for any fare, fee, rate, change, or other consideration, directly or indirectly in connection with any business or undertaking intended for profit. Within the federal statute, guys. This is the federal statute right here. This is the federal definition, I should say. We all know that there is no federal law requiring mandatory licensing other than the FMCSA, Federal Motor Carriers Association, that specifies that in order for you to operate a motor vehicle, you are required to have a CDL. You guys know, I've been showing you that FMCSA handbook throughout my other videos. This is where all this comes from, guys. Going back to the basics. That's what we did. We're going back to the basics. You have to know how to discern the difference between a motor vehicle and an automobile, and that is what the police officers failed to do. The state never gave them the authority to discuss, okay, between an automobile and a motor vehicle. They weren't given that authority, and they're not given that authority, because here's what it says. The term automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Company versus Chipotle 60A2D 118, 120, 95, New Hampshire 200 motor vehicle. 18 U.S.C. Part 1, Chapter 2, Section 31 definitions. Uh-oh. Another federal definition for an automobile, people. Oh, wait, it's not over. Here we go. A automobile is reclassified as a motor vehicle once it is used in that of a commercial capacity and or is sold by the manufacturer to a dealer and or first purchaser. See USC 15-1231 automobiles. The use of the automobile determines its classification. Meaning this. Okay. If you don't have a MOC or MCO, sorry, MCO, Manufacturer's Certificate of Origin, which is what is issued when an automobile comes off the assembly line from the manufacturer. Okay, 99% of Americans don't even know what that is. They've never even seen one. Because as soon as the car is sent to the dealership, a certificate for title of a motor vehicle is issued. So you don't get to see the MCO, Manufacturer Certificate of Origin. Okay? So, as it says here, the use of the automobile determines its classification, meaning this. You could take your personal automobile and use it as a taxi. Okay? A Uber, a Lyft. Now you're in commerce. Now you're operating in commerce. You can also take that same personal private automobile, such as a limousine, okay, and you are again operating in commerce. You could take your own personal private truck, such as a tow truck, a pickup truck, use it as garbage, etc., and you are operating in commerce. Okay, you need to know the difference between that, discern the difference between what those mean. Okay, and that's not bullshit, that's facts. That's all 100% facts. The USC 15-1231 tells you that. Exactly what you see written here is what it says word for word. An automobile is reclassified as a motor vehicle once it is used in that of a commercial capacity and or is sold by the manufacturer to a dealer and or first purchaser. USC 15-1231 automobiles. Now you see how the state definition of motor vehicle comes in conflict with the federal definition of motor vehicle. It comes in conflict in all the ways. One broadens it, one narrows it. So we're going to go down here. When a state statute and or policy or rule regulation definition come into conflict with that of the federal law, at Article 6, Section 2 of the United States Constitution, the Supremacy Clause preempts the state law and federal law prevails. Okay, and I do believe that within that meaning there is a three-step method that the courts actually use to determine the conflict. And when I was reading those three steps, this is in compliance with all three steps of that rule, because the definitions significantly changed through that of the legislation's intent. They changed. One specifically signifies and signals out what a particular motor vehicle is, whereas one applied the terminology motor vehicle to anyone getting in behind the wheel of a vehicle. Okay, so can't do that. It contradicts, it conflicts with the federal meaning aspect. State statute comes into conflict with federal law as the states are authorized. Now listen here, I've even given them validation to this. As the states are authorized to enact and enforce its own laws, statutes, rules, policies, and regulations by and through the 10th Amendment of the United States Constitution. However, that amendment and none other affords the state or any state authority to enact laws that conflict with federal laws, The two definitions come into conflict, whereas one, the state's version of what a motor vehicle is, broadens the scope to include everyone wishing to operate and or drive on the roadways and highways are required to have a valid driver's license. The federal version narrowed that scope as to what actually defines a motor vehicle, and within its definition did not include everyone needing a valid license to operate or drive on the road or highways, but only those wishing to drive a motor vehicle. The term within the definition "and used for commercial purposes" clearly establishes that a license is directed to those drivers only and not everyone, clearly establishing a motor vehicle as being a commercial vehicle and none other. It's right there in their own statutes, people. And that's not my interpretation, that's the overall interpretation. Facts. That's the overall facts that's presented right there in their own laws. Statutes that violate the plain and obvious principles of common law and common reason are null and void. Bennett versus Baldwin, 60. Also see Norton versus Shelby County, 118 U.S. Supreme Court. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation, as inoperative as though it had never been passed. Meaning this, now you want to know, well, how does the Supremacy Clause play in all that? Well, the Supremacy Clause plays in all that because of this fact here. In order for this statute to have been constructed and written, RCW 4620.001, okay, that term motor vehicle had to come from some source. That source came from the definition that they implemented. Okay? When they utilized this definition, okay, they wrote this definition to conflict with this definition, the actual definition, the one that matters. This is the one that matters right here, the federal definition, not the state definition. But this definition, this federal definition, is what makes this statute void. You get it? You understand it? Makes this definition void because this terminology of motor vehicle includes anyone who wishes to operate or drive a motor vehicle on the highways. That means anyone, family car, whatever. That's what they're insinuating here, or implying here, I should say. Okay. So now that you understand how that works, that's how the Supremacy Clause comes into play, because the term motor vehicle gave this statute a totally different meaning, when in fact the definition of motor vehicle is directed strictly towards commercial use only. There's that. So now, let's see, where are we at here? Okay, so we did this. Okay. The state's version of a motor vehicle broadens the scope, just what I was just explaining to you, to include everyone wishing to operate and or drive on the roadways and highways are required to have a valid driver's license. The federal version narrows that scope as to what actually defines a motor vehicle, and within its definition did not include everyone needing a valid license to operate or drive on the road or highways, but only those wishing to operate, drive a motor vehicle. The term within the definition "and used for commercial purposes" clearly establishes that a license is directed to those drivers only and not everyone, clearly establishing a motor vehicle as being a commercial vehicle and none other. Mm-mm. Statutes that violate the plain and obvious principles of common right and common reason are null and void. Bennett versus Boggs. 1 Baldwin 60. Norton versus Shelby County, 118 U.S. 425. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. All law enforcement be advised. Ignorance of the law is no excuse and is not an admissible excuse or defense. Henry McGowan. Greenwood versus Peacock. Persons who are denied rights guaranteed to them under federal law may vindicate these rights in appropriate cases by various remedies in federal courts, such as direct review by United States Supreme Court, obtaining injunction or habeas corpus, bringing suit for damages under 42 U.S.C. 1983, or invoking criminal sanctions under 18 U.S.C. 241, 242. Also see 42 U.S.C. 14141 A.B. Police misconduct, OSCOs, and ECW. Now, if you go back here to this Greenwood versus Peacock case, this is where I want all you haters, traitors, trolls, and bootlickers to know and understand something. Okay? If I'm given a traffic ticket and I decide to fight that traffic ticket, I go to court, they find me guilty. I appeal. What court do I appeal to? Whoopsie. What's that say right there? Oh, my goodness. Federal courts, such as directed review by the what? Hang on. I'm making sure that, why does that keep doing that? I'm making sure that you guys see that, because I want y'all to know that this is what you guys fail to understand. And for some reason this is acting up. I don't know why. Why it keeps jumping up there like that, I don't know. Why does it keep doing that? Anyway, you get my point. I don't know what's wrong with my thing, but the United States Supreme Court, okay, so your appeals go to the federal court. And if they fail in the federal court, then they go to the Supreme Court. But here's the thing. Everything you mentioned here within your notice of liability is all federal. Now, you think that the federal court is going to go against what's already been ruled and established as law? Come on, man. You guys need to think better than that. Go back in your deal and look at how law is actually done. Okay? They're not going to go against what's already set in stone. That's been set in stone and been there for forever. Okay? The most important questions you as law enforcement officers should be asking yourself right now is, 1, is my bad faith judgment, ego, or misconduct worth violating my constitutional oath and or destroying your careers? What should have been said right there, but I didn't put that in there. And or this individual's rights. 2, can I afford it? These 2 questions should be running through your mind as you read this notice of liability, as a violation of the individual's rights will result in criminal civil action against you, the officer in question, your personal capacity as well as that of your official capacity, and can extend to lien on that of your bond and or personal property to satisfy the debt, as well as extends to your courts and city, county, Department of Employment. By your reading of this notice of liability, you have acknowledged as well as just been given knowledge of the actual laws and definitions that you as an officer of the law are obligated to enforce and none other. The courts are not bound by an officer's interpretation of the law under which he presumes to act and what the actual law expresses. See Hoff Summer versus Hayes 92 and Henry McCowan. Pursuant to the federal definition, a motor vehicle is a commercial vehicle and only requires a motor vehicle to be licensed and registered in all states. Nowhere in that federal definition does it include everyone needing a valid license to drive automobiles on the highways. Only drivers of motor vehicles are required to be licensed and registered. Now, you ask, well, that's not true. Yeah, it is, because there's a thing called the legal maximum, the legal Latin maximum, which is the universal rule that they use to determine the construction and legislation's intent of a statute. And in that legal Latin maximum, it says in there that that which is not expressly mentioned within a statute excludes all others. Automobiles is not included in the statute. Mm-mm. It only references motor vehicles. All the statutes. The reason law enforcement comes under attack is for their complete misunderstanding and misapplication of the term motor vehicle and automobile. Expressed in the definitions, it does not afford officials with discretion or authority to enforce or rewrite a definition and or its meaning to fit their agenda. Meaning they can't take what they believe a motor vehicle is, meaning everybody that's driving or traveling on the roads or whatever. They can't rewrite that. But the state never gave them the authority, gave the police power the authority to use their own discretion as to how a definition is applied. Mm-mm. All states and its employees, here you go right here, what I just said. All states and its employees are bound by the federal laws. What? I actually had somebody tell me the other day that the states are not bound by federal laws. Whoa. What? This is actually right here. All states and its employees are bound by the federal laws, rules, policies, regulations, etc., and the enforcement of the state laws cannot come into conflict with the federal law. In this instance, the enforcement of a driver's license onto a driver not engaged in operating a motor vehicle and used for commercial purposes pursuant to U.S.C. 1831 is in clear violation of his or her individual constitutional rights. A federal criminal offense, 18 U.S.C. 241-242 under color of law, there shall be no lawmaking that violates an individual's individual rights. Miranda versus Arizona, 384 U.S. 436 491. Section 1 Civil Rights Act of 1871, 42 U.S.C. 1983. Listen to this, guys. Every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Go back up there to what I was telling you about where the case would go. If you failed in state court, you're going to federal court. This right here, this document right here, you could readdress this document. Okay? You could put it as a motion to dismiss. You can write it as you can actually, I'm going to get into a part. I'm going to get into something for you guys. I'm going to show you something. Okay? Redress. So, the statute, RCW 4620.001, is void as it conflicts with federal law. You have now been given official notice, and you now have 10 minutes to determine if this is an investigatory stop that you now know to be unlawful, and should you wish to proceed any further on that of trespassing on my constitutional rights, then you are hereby required to sign this notice of liability. My presentment and official documented recording of this forced under duress interaction will be placed into evidence should you fail to acknowledge the notice by way of a signature. After the first 10 minutes, this is the fee scale, my fee scale. After the first 10 minutes of the first trespass, in other words, I'm giving you 10 minutes to read this notice. Then you have that opportunity to make your decision, what you're going to do, how you're going to proceed, officers. You will then be charged in excess of $100,000 for each additional 5 minutes you wish to continue to trespass. This fee schedule is a continued running fee schedule should you unlawfully arrest, engage in that of the use of excessive force by breaking windows or removal of my person from my automobile, personal private property, causing bodily harm, and present me to a jail and or magistrate. As for the taking of my property, the fee is $200,000 initially, and then $50,000 for each additional hour my property is unlawfully impounded. And then you have the officer's signature, his badge number, and the department he works for. Now here's the thing, guys. If the officer refuses to sign this, that's why you get his name, badge number on film. Okay? You get it on film. You're recording this whole interaction with this officer. So you get his name, number, and badge number. His name and badge number. And the department that he works for. On film. Now, here's a little tip that I'm going to give you guys. In doing this, when you get pulled over, you want to make sure that you keep your hands within the view of your camera. In other words, when he pulls you over, crack your window. Unfortunately, like mine, I have to roll mine down because mine are tinted out. They're black. So, roll your window down, hand him your document, invoke your rights right away, place both of your hands on the wheel. This is just, you can do what you want to do. However, what you're wanting to do is beat them at their game. You have to understand that officer, when he goes to break your window, his argument is going to be that he felt that he was in imminent danger. He's going to say that he saw you moving around too much in your automobile after he unlawfully ordered you not to, or he unlawfully ordered you out of your automobile because he felt that his safety and security was at risk. No, the safety and security that you put yourself at risk is pulling me over on the side of a highway and automobiles are passing by. That's the danger that you subjected yourself to by standing, along the side of the road in ongoing traffic. Me, myself, both my hands are on the wheel. My camera shows that both hands are on the wheel. They never left the wheel once I handed you that paperwork, and you decided that you was going to use excessive force against me and by breaking my windows and pulling me out of my automobile. Okay? None of that and all of that is contradicted by your camera viewing your hands on your wheel, not moving. You are now not constituted as an imminent threat. And it takes away that imminent threat argument that the officer is going to use against you in the court of law as to his actions. So therefore now he cannot use good faith argument. It's all bad faith. It's a proven fact. It contradicts everything he says. He did everything out of bad faith. Okay? So there's that. And that was just to let you guys know that because you needed to know that. Okay? So, and that's just, friendly advice, suggestion. But like I said, you want to make sure that you get his name and badge number at all times. You hand him this. And I would advise that you see this blank page here. So I would advise that you go get this notarized and have copies of the notarized copy of the notarized original, but copies in your automobile. This way, when you go to do your action, it's a legal document. Whether or not he signs this or not, your video presentation, your video documentation, okay, validates the fact that you had an interaction with that particular officer who is now in association or associated with this document. Also, too, when you're filming your interaction under duress with this officer, before you just go hand this document off to that officer, okay, you need to know and understand. Compose yourself. Always act in honor. Okay? Act like an idiot, expect to be treated like an idiot, okay? Do everything in honor, people. Present him with this document, but before handing him this document, hold the document up to your camera so that it is showing this right here. Right to travel by law, notice of liability, affidavit of facts. Now, in your own personal documents, you can actually take this out if you wish, the right to travel by law, because the document itself does not actually address your right to travel. Okay? It proves that you have a right to be in your automobile without a license. You don't need all those Supreme Court case laws that say that, but I mean they're extra. That's your extra added support. Okay, let's put it like that. Let's keep it like that. So, but this notice of liability and affidavit of truth and facts, under penalty of perjury. Let's go here to the very end of this. Declaration under penalty of perjury on behalf of myself, a free man not contracted with any state. I, a free man, declare under penalty of perjury that I have researched and determined that the information and case laws cited herein are lawful and true and correct to the best of my knowledge. They are. They're 100% factual. You know, and the interesting thing about all this is none of this is your personal opinion. It's all fact-based with their own law. So, how do you beat the law? You use their law against them. And that's what we've done here in this notice of liability. You've taken all their laws and used it against them. Again, if you wish to use this particular affidavit, take my state statutes out, insert your state statutes in, your state definition in, leave the federal definition as is, and use the rest of the document. Period. As you can see. Okay? Again, get the officer's name and badge number on film. If he refuses to sign it, get the department where he works. Make sure it's on your recording. And file. Now, keep in mind too, people, here's the thing. So, in your fee here, discretion, okay? Let's say, for instance, he pulls you over, he goes back and in 10 minutes or more, he reads this and then he determines that, okay, he's not going to take any actions. Here you go, sir, ma'am, you know, you're free to go. In your personal discretion, let that shit go. You know what I'm saying? Let it go. He lets you go, let it go. No need to follow through. Now, if you down the road all of a sudden receive a citation or a notice in the mail stating that you had this interaction and you received a traffic ticket, okay, make sure you kept that recording and this document. Okay? Just remember that. So, with that said, I hope that cleared up a lot of things for you guys. If you guys would like a copy of this notice of liability and affidavit of truth and facts, you know, hit me up in the comments. Leave your email, and I will send you one, a copy, and you can reword it, address it the way you want. Okay? All right, with that being said, hey, it's early in the morning here, Dark Angel. I'm getting ready to go enjoy this beautiful day. I want all of you to remember to continue to stand in honor. Okay? Always remember, stand in honor, act in honor. You are a king, you are queens, and that's how you should present yourself, not as idiots. If you want to present yourself as an idiot, expect to be treated like an idiot. Okay? So, sometimes I get a little hot headed, but that's my nature. I'm not telling you to act like me, and I'm not telling you to act like somebody else, because that is how the social norms brainwashes you into believing that you are not acting within what is constituted as the social norms in society. Well, whoever the individual was that determines what the social norms are, I have news for you. I am a social norm because I am a man. I don't submit to trends. I don't submit to the ways of what people believe something is to be. And I'm not a follower. Okay? Not a follower by any means. Now, you have good government, you have bad government. You have good officers, you have bad officers. Just like in everything in this world, you have good and bad. Okay? For those that are good, more power to you. For those that are bad, down with tyranny. Period. End of story. For the government to sit there and label sovereign as domestic terrorists, you're wrong. We're not domestic terrorists. We're not absolutely against the government. We are just against bad government. And that's what you need to know and understand. And you sit there and you say, well, we've had this time of interaction. No, I doubt it. I very seriously doubt that that's exactly what happened. But who's to say, But all I'm going to say is this. In truth and facts, which is what we do here on this channel, truth and facts, this is all truth. And it has been proven without using hundreds and hundreds and hundreds of case law. Oh, I know what I was going to cover with you guys. I forgot. So, under your fee schedule, right here, under your fee schedule, give me 1 second. Give me 1 second. I'll be right with you. Give me 1 second. I gotta go over to my desk real quick. Okay. I knew I was forgetting something that I wanted to make mention in this video, because it is, again, okay, there is a case out of Florida. I do believe it's called Tresvent. I want to say that is the name of the case, called Tresvent. Let me look here. I want to make sure that it is the one I'm thinking of. Because it is of significant importance. Yeah, here it is. So it is of significant importance. Okay. So this is the Tresvent Case Damage Award Standard, and it's called Trezevant. Okay, Trezevant. Evidence that motorist cited for traffic violation was incarcerated for 23 minutes during booking process, even though he had never been arrested and at all times had sufficient cash on hand to post bond pending court disposition of citation, was sufficient to support finding that municipality employing officer who cited motorist and contrary Board of Criminal Justice, which operated facility in which motorist was incarcerated, had unconstitutionally deprived motorist of his right to liberty. 42 U.S.C.A. Section 1983, Tresvant versus City of Tampa, 1984, 741 Federal 2D 336 NA. The jury verdict awarded $25,000 in favor of the motorist who was unconstitutionally deprived of his liberty when incarcerated during booking process following citation for traffic violation was not excessive in view of evidence of motorist's back pain during period of incarceration and jailer's refusal to provide medical treatment, as well as fact that the motorist was clearly entitled to compensation for incarceration itself and for mental anguish that he had suffered from entire episode. Did you hear that? Just for the incarceration. And also within that case, it was written that he was awarded $25,000 for each additional hour he spent incarcerated. I don't know if you guys can see that on the camera or not. But if you can, it is right here by my finger. Right there. See that? Yeah. Facts, people. Facts. So, this right here, under the Tresvant is legit. 100. Okay? Alright. Well, listen. With all that being said, like I said, act in honor, stand in honor. Be a king, be a queen. Do everything right. If you wish to notarize that, get it notarized. That's why this page is blank here, because I have a separate notary that goes here. And I'm not going to show you all that because it has all personal information on it and things of that magnitude. But again, you sign it here over standing in honor, date it here, put your name here, okay? Officer's name, badge number, department. Even if he doesn't write it in, you write it in. Again, use discretion. If he lets you go, let it go, but hang on to your paperwork in the event that you receive a citation later on in the mail. Okay, then you can address the issue and you have your evidence and you have your proof, and make sure that it's dated, the proper date that the duress interaction occurred. Okay, with that being said, this is Dark Angel. Ladies and gentlemen, I'm out. Deuces.